Well, hello everybody out there. It is Monday. It is 6 o'clock Eastern Time. I am Brian Burke from the law firm Shehab Burke here in Dublin, Ohio. And well, also with me, but not technically in Dublin, Ohio, is my partner Sam Shehab. Sam, how are you?
I'm doing great, Brian. How are you today?
I'm doing pretty darn well.
I understand that you are hearing echoes today.
Yes, only due to technical reasons, not due to my mental health. Due to the broadcasting
You never
situation
know.
now, I'm getting the. Okay, fair enough. I hear our broadcast is coming through well through the nice person who's watching for us. So I think we're ready to go here.
Wonderful. What's today's topic?
Well, sir, today's topic is H-1B visa stamping inside the U.S. and other immigration news. And
Excellent.
I guess that's, the fact that we have multiple topics is a bit of a preview of the fact that we don't get too much on H-1B stamping in the United States. Yeah. So,
Well, I mean, the visa stamping issue obviously is a long time coming. The only reason we don't have visa stamping is a pure impotence on behalf of our wonderful Department of State to let and force people to travel across the globe to get a piece of paper. The counter argument, obviously, I know you're contrarian, Brian. You like the counter argument. I'll give it to you. The
I'll give it
counter
a try.
argument, the counter argument is a stamp is a permission to present yourself at the consulate, at the border, and therefore should be issued abroad, not in the U.S. But I'm going to give you the counter, which is you write it on paper the way it should work, but it works completely different. It's about time to understand how things really work and have our laws conform to the reality. Um,
That's about
people
where I
with
land, for the record.
yeah,
Legal discussions are fun, but I always prefer the law to work in a reasonable and logical way. And the fun challenge of our job as immigration attorneys is that we're perpetually expected to explain to our clients why what I'm going to tell you sounds ridiculous, and that's because it is, because the U.S. immigration system ridiculous.
is ridiculous. Yes,
Yeah.
and for me, rolling back the time, I don't know, 10, 15 years ago, maybe 15 years ago, they had a program. I have no idea why they stopped it. Charge a fee, charge $100, charge $300, whatever reasonable, charge $400. You know, instead of paying the
Yeah.
airline ticket and the time wasted and the energy wasted. I mean, unless maybe you think the Department of State has a contract with the airlines so they can make more money.
I don't know. But, if you're going to bring up the term contracts, I can't help but think about the outside services they use to facilitate visa issuing services all around the globe. There's like two companies that provide this service to the Department of State, and if you're in certain hemispheres, one company controls the visa application process, the scheduling and making appointments, and there's another company that does it for the other half of the world. I can't help but think that those people would be very much against this because if they're cut out of the process, that's just less money for them to make on every visa application. Just a
Hmm.
thought.
Yeah.
Let's
Um,
perhaps get to the substance of what we know.
yeah, let's do it.
Okay, so here's what we have. The pilot program is apparently going to begin in January 2024. There's a limitation of 20,000 participants at first. And full details are expected to come out soon through a publication in the Federal Register. And I have looked as recently as today, and I have seen no new publications from the Department of State, but sometime during the month of December, that policy is expected to come out. And that's pretty much all we know. We have a number and a vague time frame, and we know policy is specifics are coming soon. That's
So
what
what
we
does that
have.
number mean? What did they say about that number?
only 20,000 participants.
So are they going to hit that 20,000?
I presume so. I would bet there's 20,000 people in the United States who would love to have a visa approved before they need to travel outside the country.
Yeah. So last time, if I remember correctly, it was restricted to those who had prior H-1B approved.
Yeah.
So they were not issuing new H-1B for somebody that, let's say, on an F1 visa and never had an H-1B visa in the U.S. and these people would not get the benefit of that program. They want you.
Well,
they want you to go outside the country and get that H-1B stamp for these people.
sure.
So perhaps this time I would not be surprised if that's what they will be doing.
Oh, for sure. But I would argue the premise of the people who are waiting outside the United States, who must apply outside the United States, that they won't see any benefit from this. Because if the consulate is not backed up with 20,000 or so people, there you are, Sam, you're back. That's a quicker amount of time in which somebody can actually get a visa when they need to interview. Taking the applications out of the consulate means faster applications in the consulate, in my book.
Well, we don't know what's going to happen this year, but I am not going to be surprised if they said it's really those who got H-1B visas.
Oh yeah. Well, I'm excited to see it. I'm going to keep an eye on it, and we'll talk about it here.
It's
And
20,000 only.
I guess,
and they're going to get the easiest 20,000 to process, Brian. They're not going to get
sure, I would fully agree with that.
20, yeah, any 20,000.
And Sam, there's going to be a press release where they pat themselves in the back for saying we processed 20,000 visas in record time.
Exactly. It's going to be,
Yeah.
I'm assuming, it's going to be those who received the H-1B stamp before, probably those who had, I don't know. So that one's questionable. Who have U.S. degrees, probably. Because when you restrict it to those two, there's nothing to do. There's nothing left. And zero criminal record, perhaps have been in the United States for a significant period of time, so there's enough history about these people that it's not going to be an issue.
Yeah.
3, 4 years, 5 years in the U.S. So it'll be interesting to see what's going to roll out. But it's going to be in the situation where they are going to just skim from the top the simplest cases that they can approve, which I have no problem with the idea. And they should do that because you should start with the easy cases and then expand it to more difficult cases.
Well, I agree with you. I, again, subscribe to the premise. If the easy cases are no longer in the consulate can take care of the hard cases faster.
Exactly.
So,
do you know whether the H-4s are going to be included?
Again, the information we get is a trickle. We've all been hearing over the course of this year, it's coming. And to be clear to people, the statement, not the regulations, but whatever we get in the Federal Register regarding this, that's when we get the deluge of information as to what the policy is. But we don't have those details. I don't know whether those H-4s will be included in those 20,000 or not.
So what's the execution this month, right?
January. Well, the details of the
next-
program to be released to the Federal Register this month, with the program to begin in January, as early as January 2024, as I believe what they said.
So when they talk about the Federal Register, you're not talking about an intent to make regulations. It's just a publication
Can't
of
be,
an
yeah.
event. Well, no, there's no way.
If they're
They
gonna-
don't have time.
Yeah.
Okay.
So,
All right.
like I said, we don't have the details until we see it.
Yeah. Well, sounds interesting. Sounds like a step in the right direction. A small step nonetheless. A baby step nonetheless. Maybe by 2020, 2030 or so, we will have a full running program.
Yeah. So, perhaps we get to our next news item then?
Your favorite item. You've been dying to get to it.
Okay. So, if the H-1B cap stamping in the United States, I call that a grain of sand upon which a pearl is forming. It's going to be good, right? The next one is a sort of favorite whipping boy of a potential law that people love to talk about, and I don't know why. It's called the Eagle Act, Sam. People have been talking about the return of the Eagle Act lately. It's been reintroduced in Congress with bipartisan support, and people are out there saying, well, this is the Eagle Act, the Eagle Act, the Eagle Act. Sam, the Eagle Act has been around since 2008. You know, a couple years, the Eagle Act's going to be able to go to the bar and get a beer. Bottom line, I don't count on that act at passing anytime soon. A bipartisan reform to the immigration backlog is what the Eagle Act is in summary, and I don't buy into it happening anytime soon. I think the political climate has only gotten worse, and that's it for me.
Yeah. Well, no, that's not. That's it. We need you more, Brian. But
okay. Well, what do you have? If you give me...
No, but I agree. No, I agree. It is sad that some people are talking about this thing as a realistic possibility.
Yeah, and we've had this conversation internally here. What are these for the Congress people who introduce them to you, Sam?
I don't understand the question.
Well, it's a leading question, but I have an answer, obviously, so I'll tell you. These are publicity stunts of sorts for these congressmen, you know?
Well,
hey, I introduced a law to say X, Y, Z.
Yeah. Well, I was even thinking beyond that. I mean, that's, yes, you're right. For those who introduced it, yes. But the reason this legislation or proposed legislation will never pass Congress in an election year is the following. The Republicans will never give a Democrat a victory, okay, that they can use to campaign on. We pass a bipartisan legislation. We convince the Republicans to come around and stop being destructive, you know, and we passed it. And the Republican will say, I will not give you my vote in a million years for you to do that. And the Democrats will do it because if they get it, they will use it. And the Republicans don't trust the Democrats not to do that, even if the Democrat promised not to do that. And therefore, nobody is going to come together on passing any law. I mean, the government is about to shut down 3 or 4 times, and they're not able to pass anything. So you're telling me that they are going to pass an controversial immigration legislation in an election year? Yeah. And anybody that talks about it and think that this thing is realistic is ridiculous.
Yeah, so literally once a quarter, somebody does something like this, and we start getting emails saying, Brian, what are the odds of this? What are the odds of this? And I'm going to repeat now my usual mantra for these things. When it's signed by the president, then it's worth talking about. Don't worry your life over it until then.
Right. Well, yeah.
Bills being get introduced all the time, yeah.
Yeah. So that's your favorite. Your next favorite one is H-1B.
Yeah. Yeah. Right. H-1B, I do love talking about, H-1B. And the big H-1B news, and it's still the big H-1B news, is the new regulations introduced relating to H-1B visas, about a month and a half ago. And these covered things like changing the definition of specialty occupation, the degree requirements, how the H-1B cap works, entrepreneurial owners of companies being on H-1B, things like that. So many things out there in these new H-1B regulations. And one of the things we mentioned when we talked about it live here is a fun part of the U.S. regulatory process is that when they put out new regulations out there, they invite people to comment on them. And like I said, these regulations have been out there for about a month and a half. And there are comments out there from people like you and me, the people in our audience, regarding the regulations. And for anybody who is included in or interested in this, what I will do is, because I have access to the chat here, is I'm going to post a link to the actual comments for anybody who's curious to follow along can read.
Brian,
And I figured,
I was sorry to interrupt you. Excellent point, but I was just googling the H4
yeah,
for the stamping.
yeah,
So it looks like the H4s are not included.
not included in what
In
sense?
in the stamping, they are not issuing H4 dependent stamping, but they're issuing H1B principles only, which tells
Okay,
me
so
this program fails the basic common sense. But this thing's
yeah,
subject to change, by the way, because now everybody's going to jump on them and say, "Are you stupid or what?" I mean,
that
what
is
is this?
ridiculous. You know,
Yeah. So,
it's the people with families who have everything to lose without kicking out of the United States, whereas the
yeah,
people who are single, well, you know, they're a different stage in life.
yes, yes. Um, but um, um, but yes, go ahead.
Well, I thought, you know, first of all, it would be nice to remind people that they can make comments as well and, you know, influence U.S. government policy because they will read your comments on these things, and if there are enough comments on an issue, they will actually comment on the comments when they make final decisions on the regulations. And I thought it might be fun to sort of look through some of these to see what people are saying, you know, in terms of what they think of these new regulations are that are out there.
Yep.
And so I have a couple. I realize, Sam, I have a slight technical issue in that I can make my entire screen my web browser where it has these things
There's no
are.
problem.
But if you're there,
No, it doesn't bother me. It's okay. Just
okay,
go
well,
ahead.
see if what I put up here is legible. And let me get to my browser here, and
All right. Awesome.
yeah, indeedy. Oh, there it is. And now I'm going to see if I can hide you for a second, Sam, so I can put this here. You should be able to talk, I think. No, I don't think that. I don't. Nope. 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 Well, so maybe I will just sort of comment on the issues that I have here
But that's
in front of me because we had
so
this.
so these comments are fantastic comments, and we were reading them today, and they were very
Yeah.
helpful in just getting the feedback that we're getting on these H1Bs, which makes a lot of sense.
Yeah.
So go ahead,
So
Brian, if you can see. Yeah, throw in the
yeah,
first
I'm
one.
gonna not bother putting them up on the screen because it's kind of hard for people to see. But I'll tell you what the general thoughts are from the people out there. Big support for changes to the H-1B lottery system. About pretty much every other comment that I get is from somebody who is on F1 status saying, I've been through the lottery 3 times. I haven't been able to get selected in the lottery. I'm sick and tired of people gaming the system. There you go. So kind of a fascinating paradigm there. Another one that's sort of, well, Sam, should I try reading one of these things live, you think?
Yes, please do.
See what the comments are? Okay.
Yeah.
Well, I won't be able to put it on the screen, but you guys can look at all the comments here, and you really should because they're kind of fascinating because it's people's best thoughts on the new H-1B regulations. So here's one that's posted anonymously. You can post them anonymously, but here you go. I am glad to learn that the regulators are finally taking measures or propose to take measures to make sure that every H-1B lottery participant can have a fair chance of being selected. As someone who is still undergoing the H-1B lottery process myself, I understand deeply how important it is to ensure the integrity of this process. For me, all those who have spent years studying in the United States and have the chance to start a career here, H-1B is a key step in achieving career goals and contributing our knowledge to the wider economy. Therefore, a fair process in the H-1B lottery is absolutely needed so that those who play by the rules and those who do not benefit at the cost of others are selected. I believe this can help promote a sense of social justice and make people realize that ethical behaviors are encouraged while unethical behavior will be punished. The benefit will be not just the H-1B lottery process, but it will also benefit the overall society in general. So, speak of the devil, kind of the comments I'm seeing, people on F1 status or people trying to get into the lottery, kind of supporting the new version of the H-1B lottery system, wherein people are saying, where the proposal is one registration per person, one chomp of the bit per person.
So one person and one chance to enter the lottery. Doesn't matter how many opportunities. Okay, excellent. So it's unanimous support for that. And finally, they came out with a solution that makes sense.
Yeah. Yes. Now, here's another one I'm reading from, I'm not going to read their full name, even though they made it public, but from Bala on the public comments here. And this is another one of the trends that I saw in the comments that are out there in the public. The stricter definition of specialty occupation means with my MS in telecom networks, I can only be a network engineer, but there are actual software engineering roles inside networking companies that are very important, and I wonder if USCIS would understand that. This concerns me. So there's a lot of people commenting, basically saying, I'm worried that I'm going to be hindered in my ability to work in the United States due to the proposed changes in what degrees are accepted, the narrowness of that.
I find that that intent to narrow down degrees and getting in that nuances to be rolling back the time to the 1900s. This is not how professionals work. I was on the phone today with somebody with a medical background, medical research background, and he's talking about maybe working for Apple to help develop a medical app. Okay, how are you going to have these talents and work in cross industries to achieve greater accomplishments for themselves and for the country? It makes no sense. Yeah. So I find this to be incredibly backward thinking in terms of trying to accomplish anything positive on the H-1B program.
Well, a lot of the comments similar to this one. Again, the idea that I'm worried I'm going to be pigeonholed into a single occupation. One thing that sort of, I read in favor is that people who are making those complaints, and I think they are valid ones, have been in the United States for a long time. People with been in the country for a long time, have been building lots of experience. And what doesn't change is the ability, as I recall in the new regulations, is the ability to establish your qualifications through experience as well. Meaning, those expert opinions who can say, so-and-so's work in the field of this for X amount of years pushes them to the equivalency of a degree in computer information systems. So maybe somebody like this individual Bala, whose comment I'm reading, is maybe not terribly trapped in the degree of telecom networks or the idea of just being a network engineer.
Yeah.
That's
just the whole thing is silly. I mean, if the position requires a bachelor's degree in the general field and area, the group of fields, I mean, there's so much crisscross unless you're doing stone engineering, unless you're doing something that's completely, 100,000 years old, that's not in line with what's going on today. Cross discipline is so essential.
Yeah. Well, that's where I think the coolest ability to have the coolest innovations are. It's bringing technology, computers to fields that have not been touched by them as much as they could.
Yes.
Yeah.
Yep, I agree.
So I got to comment on the last sort of string of comments that we've seen here on the regulations and maybe wag my finger at the general public a little bit. One of the things I see here a lot is, hey, please make changes to fix the backlog in the immigration backlog that's so commonly the topic during our live talks here. And a couple problems with that. One, that's not what's on the regulatory agenda right now. So the government, isn't trying to do anything about that. And secondly, that's not something that can be changed by regulation because it's actually written into the law, how many visas are available and who's eligible for them. But, I like really reading these comments because I don't know who these people are, but they're kind of echoing the people who are in our regular audience for this presentation, The backlog stinks, please get rid of it. And the fact that people are coming to this venue to make that complaint kind of illustrates to me that there's so little opportunity to comment and complain to anybody about this issue. Because obviously, considering my opinion on the Eagle Act, Congress isn't listening. Not really, anyway.
I agree. Well, Brian,
So
let's take some questions.
okay. All right. So hopefully you'll be able to see him, Sam. I think even in this version, we'll see what we get. Hey, I think you can.
All right.
So, question here from Explorer Dreamer. What happens if I-485 was denied, raised MTR, but can I extend H1 using underlying I-140? Or I-140 is also being questioned. Can I stay in the U.S. via H1 in case AOS is denied? So, for me, when I think of an adjustment of status denial, it's just going to be that. Typically, when you see a denial on adjustment of status, it's not going to question the I-140. Would you agree, Sam?
Yeah, that's a completely different thing. And if they do, then that would be a motion of intent to revoke if it's been approved,
Yeah, notice.
or an RFA on the I-140, or a denial of the I-140. Yeah, completely true.
I guess, it's possible that one can slowly roll to the other, but if you get an adjustment of status denial notice, it can't, in good conscience, dispose of the I-140 as well. It's just not how they
100% no. No,
Yeah.
it will not.
Yeah. They would do work to attack the I-140.
Okay, can I extend H-1B using underlying I-140? Well, if you are on H-1B status and your I-140 is valid, is approved, right? And the there's one more requirement here. And the priority date not current, which is possible. They can deny after retrogression.
Yeah,
you can definitely extend your H1. Yeah, no problem.
That's that reminds me of something that I kind of wanted to talk about today, Sam, and we haven't talked about it in a while. Retrogression and why are they acting on cases right now? Why are they sending out RFEs on cases they can't approve? And the idea came up I was talking with a client today actually about it. It's just trying to clear out cases. They love to get rid of cases, waste time on people's cases they can't even adjudicate, and get rid of them by finding reasons to deny them.
That's not very efficient.
In the past, they would. Yeah,
I've seen it happen in the past, but that's not an efficient way to do it.
Well, they would send out massive supplement J RFEs or portability RFEs or medical exams RFEs.
We haven't seen that.
Not recently, but it's something that stays in my mind, I guess.
Yeah. And I think, can I stay in the USA via H-1B? The answer is yes. Even if the adjustment is completely denied, is absolutely yes. And you can stay extending your H-1B for as long as the I-140 remains valid and as long as your priority date remains not current. The answer is yes. And you can file a new perm if the I-140 that you have is not approvable. Let's say, I don't really. If the I-485 is denied, what reason? I think what underlying behind the question is a little bit of common sense we should apply. Is what are the typical reasons an I-485 is normally denied? And let's go through those. Typically, is procedural error.
Oops.
This is signed. This exhibit is just completely procedural that can be fixed with paperwork. So that is good news because that's normally somehow eventually you can get back to fixing it.
Sure.
The other things that are cause for denials for the I-45 are normally that are substantive in nature, are criminal background, medical background, political background, right?
Yeah.
Or a misconduct on the application, meaning that a misrepresentation,
Fraud or misrepresentation, of course. Yeah.
yeah, on the application, right? So,
Yeah.
do any of these things affect the H-1B approvability? Becomes
Yeah.
the
And
question,
that's, yeah.
right? So,
And you don't know that until you see the adjustment decision notice. You don't know. This is a hypothetical, of course, from Explorer Dreamer. But if
that's a good
when
one.
you read that I-45 decision notice, of course it is. You read that decision notice, it says, "Oh, we think you engaged in fraud or misrepresentation," and then you can imagine how that would go, rendering you inadmissible. That's when you start thinking about the H-1B and the impacts there, for example.
Right, exactly. So because the reason I'm bringing this up, Brian, is because while the answer is yes, you can renew your H-1B, and yes, you can stay on H-1B if the adjustment status denied. But if the adjustment status denied because of alleged fraud, probably H-1B is not going to be approved because you committed fraud on the U.S. government. If the adjustment
Yeah.
status is denied because of medical inadmissibility, the H-1B will be approved because medical inadmissibility for a green card does
Yeah,
not
it doesn't
affect
matter
the
to
H-1B
H-1B.
petition. So the answer to the question goes deeper into the case and understanding why it was denied to really answer the question, can you really extend your H-1B and stay on H-1B? Mechanically, yes, but that's a superficial answer. You got to go deeper into the
Yeah.
case to be able to answer that question.
When people ask me these hypotheticals, I say, I can speculate, but ultimately you don't know until you see the decision notice you get from USCIS.
Until you get to see the case itself and how it's built and what the issues are.
Yeah.
Yeah.
Yeah. Yeah.
All right. Excellent.
Let's keep it going here with our questions.
Yeah.
Let's see here from Vishal. H1 approved in 2022, canceled without prejudice on H1B stamp due to B2 interview in January 2023. Also, employer withdrawals petition on February 2023. Can I still use the H1B outside a lottery?
So okay.
No? Yes? Okay.
Well, that's an excellent question. Though, go ahead, Ryan. I don't have a precise answer. Yeah.
So the way the regulations read is you're considered counted against the cap if you've been issued a visa or actually been on H-1B status. And I'm seeing somebody here who was issued a stamp. But we have seen pushback before on this issue, even when somebody stamped, USCIS saying I don't know about that, and I can't remember how that one played out. I think we were successful in arguing against it.
Yeah. If the H-1B stamp is issued, that's sufficient for the case for that visa to be preserved, for that H-1B count to be preserved for the foreign national. Okay, if it's issued. Obviously, how they make sausage in the back room, we don't understand. How they count and discount, because there's any unused H-1B, they need to put them for the next year, use them for the next year allocation. But they claim that they have a good tally of what's going on. It's impossible that they do. However, it's my opinion, and I stand behind it. Doesn't mean that USCIS will agree with me, but it doesn't mean they're right either. That if you are stamped, that H-1B, will count. Now, if the withdrawal occurred prior to October 1st of that year, if the withdrawal occurred prior to October 1st, you will lose that visa number. I think we've seen that happen. USCIS says you withdrew it, that was enough notice for them, they take that number out. If the withdrawal occurs after, I don't think they do that. So if the employer withdraws after and the stamp is issued, I think you make a good argument for that visa number is yours and you should not apply for the lottery again. Now, USCIS may disagree, but that's how I feel about the analysis for this question, and that's a
Yeah,
good
the
question.
problem that Vishal has here is a 2022 approval, October 2022, with a withdrawal in February 2023. I think there's a higher possibility of scrutiny on this scenario. But that's ultimately, for somebody like Vishal, that's if an employer is willing to take a risk, it's a case that they could consider filing and seeing what USCIS says.
But see, approved in 2022, so it's effective October 1st, 2022, right? So we
Yeah,
cross that
exactly.
line into the next year, okay? Just the way I've seen them, once you cross that line, they don't really count anymore. Because if the withdrawal happens before, it's easy for them to count.
You're right.
After the fiscal year.
I think if one of our clients, an employer client, came to us with this scenario, I would warn them, due to the denial, there may be extra scrutiny on this, and I cannot be certain that they would approve this, but I think if you understand that risk, there could be a case, worth filing here.
Yes. I will take a chance. At the end of the day, it's just a filing. I mean, it's not a big deal if they say we disagree. Yeah.
Yeah, but if they say you're kept subject, well, you come back later.
Yeah. I mean, you're not going to find out there. And that question can be answered differently by different officers, because we're into areas there's no clear answer. There is what you do. You take the law.
Yeah, exactly.
You take the law, you analyze it, you break it down, and we, as attorneys, we're programmed to argue reasonably on behalf of our client in a positive way. The government mindset is negative. The attorney mindset is positive. That's not critique of the government in any way. I'm not saying the government is bad and we're good. We are, but that's not what I'm saying right now. What I'm saying is the government power, where's the government power comes from? The government powers come from the ability to say no. The government power does not come from the ability to say yes. Because if they say yes to everything, they have no power. Their ability to say no is their power. And therefore, their mindset is negative because that's the exercise of their power. So they always push back on things. We as lawyers push in the other direction. So I'm looking at this and I'm saying that I can make a decent argument in favor of this case, pushing forward. I can't guarantee it, but I feel that we would have a good case in this situation.
That's fundamentally how any conversation like this has to end. I think you can make the argument, but the government can say no. And even if I'm right, they can say no, and it could be a big fight and could take a long, long time if you really want to fight something like that.
Yeah, and the issue in any case is it worth a fight? It's a green card denial. It is a worth a fight. If it is not a green card denial, it's not a worth a fight.
Yeah.
Maybe. Yeah. All right, next one, Brian.
And very important one. Sam, get well soon.
I'm feeling great. I just did not want to sit.
I saw him today. We did, yeah.
I did, yeah. I did show up in the office today for a little bit. As a matter of fact, I wanted to come in for about half an hour, and I think it ended up being like 4 or 5 hours because one thing led to another, and I couldn't leave.
You told me you were leaving. I called you on your cell phone to ask your opinion on something, and then you half hour later you walk into my office and say, "What? You're calling me?"
Yeah. I mean, time flies. But I did not want to sit in front of Brian and breathe on Brian for 2 hours or 1 hour as we're doing this presentation.
That could be good YouTube programming, Sam. That could be what people really want to see. Watch live as attorney catches disease.
Or as attorney deliver disease.
Yeah, there you go. It's something for everybody.
Yep.
So, an interesting question, Emily Marshall. How would the system work with the denial of a 221G for stamping stateside? I don't imagine, much 221G. I imagine, I don't know, Sam. What do you imagine we get?
I'm having hard to understand. I'm having hard to understand the question.
So I think this is a question relating to the new H-1B system.
Oh, for the stamping?
The H-1B stamping system. Yeah.
That's an excellent question. Who knows, right? Given the fact that they're going to select only 20,000, okay, I'm assuming they're going to select cases that are not 221G-ables, meaning that they are clear cases in which there's no confusion on them. Honestly, I draw back from the last experience only. So I do not know whether this experience is going to be like what happened before. There were no 221G, and there was no question. It was incredibly mechanical. The process was very, you send the passport, okay, there's some fees, you send it out, it comes back. There was no scrutiny whatsoever as far as employment. There was no consular function involved in the processing of the H-1B extension, because you are in the U.S., you are on H-1B, but you may be required to send paycheck stubs and a letter from the employer, perhaps confirming your job. But I don't think there's anything back then at any level of scrutiny whatsoever. It was incredibly mechanical process.
You got my brain moving, Sam, as to how they're going to process, because Department of State, for example, does U.S. passport applications here in the United States, and you go to like a post office and they send that off there, or if you're doing a renewal, you can send it off yourself. I just can't imagine them I just thinking about the systems they have to have in place to do this. Are they going to have an online portal, or are they going to have us send them in manually? Are they going to send you letters? I haven't seen any existing functionality that would seem to match up with this function.
Everything has an online portal anymore, Brian. I'm assuming. I hope that they do
Well,
have something online where you can go
Well,
in.
I mean,
and
they
create an
have
account.
for those. They have the Consular Electronic Application Center where you apply for visas online. Maybe it would be. I guess maybe you'd just be doing it using that existing system, but they
We'll
don't
see.
have a
We'll
scheduling
see.
system that they use. Yeah.
Yeah, we'll see. But yeah, last time there was no 221G issues. There was no rejection because you're in the U.S. on H-1B. So you may have to only prove that you're working a very minimal standard last time when they've canceled that program. But yeah, that's basically sharing at least my memory recollection from last time when they were doing it
Couple,
how many
comments.
years ago. Yeah. Next one, Brian.
Couple comments here from Explorer Dreamer. H-1B pilot will be filled on 1 to 2 days. All Indians with EAD will apply immediately and get it filled. And here's another sort of related comment. 40,485 people with less than 2-year AP all are eager and ready to get H-1B stamping and travel.
Yeah, for crying out loud. Please. I mean, it's insanity. It's insanity, Brian.
Well, Sam,
You can't get an AP. You can't get a stamp. What is this?
well, you're right. The AP processing time is absolutely criminal. But you know how we're often in this venue here, Sam, talking about use of the EAD violates your H-1B. You're out of H-1B status if you're not if you're using that EAD. And you're taking for granted these people are going to be in H-1B status. I imagine people with a valid H-1B approval that they're not using anymore, applying for these visa stampings, which I guess they should be eligible for them.
I bet you anything. Anybody with an H-1B stamping in that first group, and maybe the second and the third, must be invalid H-1B in the U.S.
But does the government know if you got
It's a 5-minute questionnaire.
No,
Three questions with a signature under oath.
well, I'm excited to see what those questions.
Hire Brian to
are.
ask those 5 questions. He'll write them with his eyes closed. Are you on H-1B status at this time? Have you used an EAD since you've entered the United States? Have you stopped working? And were you non-productive at any time while you're in the United States during your H-1B time? Have you otherwise violated your H-1B status that you are or are not aware of? And 5 more questions like that, and then you sign. And if you cannot sign those questions, don't send your stamping. I don't think the H-1B stamping is designed for any EADs, anybody who's not on H-1B.
Well,
And
yeah. I'm very excited to see how it will play out.
25 cents would be my bet. Anybody wants to take me on that bet? 25 cents. One bet only. I'm not going to bet with everybody.
All right. Well, we'll see who takes it. I'll take you up on it, Sam. Sam, just to keep the logistics easy, getting that quarter towards the nation.
Venmo.
Rather.
Don't tell the
a
Biden
question
administration on Venmo, because you'll get audited now by the IRS. It's a different story. That's a different YouTube video, Brian, about taxation.
Yes.
Go ahead.
Yeah, let's put on our tax attorney hats, which we are not. So here's a question from Swami KMS. My priority date is December 2013. When it became current, my I-140 is in process due to my job change. Can I sue USCIS for moving too fast, too soon, even when they didn't have enough visas to distribute?
Swami.
So, bottom line, Sam, what do you say to somebody who is frustrated that they didn't get a green card, but their priority date is not current now, in terms of a lawsuit?
Yeah,
Oh, impractical. Would you agree?
I agree.
So my short answer to your question, Swami, is if a visa is not available to you right now, any sort of lawsuit against the government to get them to make a decision in your case isn't going to go very far, because the government will come to the court and say, we don't have any visas left. Too bad.
You know, suing the government can solve a lot of problems for people, and those who are entitled to a lawsuit should sue, but those who are not entitled should know that they are not, and don't waste your money. You can't sue. I mean, I know you're frustrated, so I mean, you don't mean it. You're not going to go spend,
All right, a bit of
hard-earned
follow-up
money,
here.
hard-earned money trying to go after USCIS. My point for suing is to direct USCIS not to issue EAD green card to people with priority date more than current visa bulletin filing date. Yeah, here's the reality. They get to make mistakes. They get to do things incorrectly, and there is no accountability, and there's no consequences. And no, you cannot sue.
That's
I mean, that's the sad reality. It's called the power of the government. Okay, the immunity of the government. We can sue the government in the United States, but it has to be pretty egregious from a practical standpoint. You can. Anybody can sue. By the way, you can file a lawsuit. Any lawyer can file a lawsuit. Then you get thrown out in no time.
yeah.
But you can sue. The question is not can I sue. The question is can I win.
Can I win? Yeah. So, a question here from Rahul Jain. Hi, I used my AP to enter recently. My H1 extension is approved till November 2025. Can I get my H1B extension visa stamped in US in January? So, layer one, Rahul, is we got some more details. 20,000 people eligible beginning in January 2024, but we don't know the exact specifications of the program. But if you entered on your AP and then after you entered the United States, got an H-1B extension, it sounds like you would be back on H-1B status, meaning, it seems believable that you could be,
We
considered
don't know the
for
rules.
stamping.
Yeah, we don't know the rules enough to answer the question now in good faith. We just don't know enough. There's not enough information. But I would say very plausible until we know more.
So a question here from Rahul Jain, to follow up from him. My AP is expiring tomorrow and renewal hasn't been approved. I recently used AP to enter the United States. Can I travel to Mexico and come back on H-1B using automatic revalidation? Will my travel lead to abandoning AOS?
Whew. Yeah. Please don't. I mean, just this is risky business. I know it's hypothetical, Raul. You're not going to do that.
Yeah.
So this is something that Brian and I have talked about, and I know other attorneys may have different opinion or look at it differently. So we look at things a little bit more structured and deep into the words. And our read is that if you really has to be on a non-immigrant status, leaving the United States and then coming back, you're not on a non-immigrant status on advanced parole.
But
Brian,
again, Rahul had that question suggesting that he might be on an H-1B status right now because he got approved. But it's hard to read these facts, I guess. But I guess the executive summary, I agree with you entirely, Sam. that automatic visa revalidation requires you to be in status. If there's any question as to your status in the United States, I would say there's a question as to whether that automatic revalidation would be permissible. When it comes to travel outside the United States with a pending employment...
How do you interpret Raul's that he believes that he is on H-1B?
Well, per the prior question, he said I used my AP to enter recently.
Can you go back on that previous?
But my H-1B, I'll put it back. I think I see your point, Sam. So he uses AP to enter recently, and his H-1B extension is approved until November 2025. I was assuming that after he had entered the United States.
Yeah, we don't know that, right?
Yeah, you're entirely right. And this is where we perhaps should put in our little disclaimer here, Sam, about the nature of these sessions and the questions that we get asked.
Yeah.
So please remember that when we're answering these questions here, we're only getting a little bit of snippet of information. We don't know all the details of your immigration history in life. And the devil is absolutely in the details when it comes to immigration. So please remember that an attorney-client relationship is not established pursuant to these sessions for all the reasons said and more. And when it comes to actually making important life-changing decisions on your immigration in the United States, you should talk to an immigration attorney of your choosing, really personally, one-on-one, before making any decisions.
Well put.
Thank you. So, again, Raul, whether or not you are in H-1B status, just that fact alone is a complex question, which is probably a bit difficult to answer in this, venue right here without sitting down and staring at your documents and really talking about the details of your history. So, going to keep on going here.
So, Brian, back on the automatic.
Oh, yes,
I'm sorry. Yeah. So back on the automatic revalidation. So prong number 3, and I looked it up here under
CBP website, right?
Yes, has maintained and intends to resume non-immigrant status. So it says that you have maintained and intend to resume non-immigrant status. Now, it means it doesn't have to be the same non-immigrant status. It can be. It doesn't say the same.
H4 to F1 or whatever. Whatever.
Yeah. So it says the provision of this section are applicable only in the case of a non-immigrant alien who is in possession of valid I-94. It goes into full detail. Is applying for readmission after absence not to exceed 30 days. It goes into full details, and then says very short. Article number 3 has maintained and intends to resume non-immigrant status. And then it goes to number 4 after that. That's it. So our reading of that section, meaning that if you're on advanced parole in the United States and leaving to get on an H-1B back for automatic revalidation, you haven't met item number 3, which is you were not maintaining, a non-immigrant status. You intend to resume a non-immigrant status. The second part of that prong is yes, but the first part of the prong is you were not maintaining non-immigrant status. So if you're on advanced parole, you should not be. Now, I'm very much aware of a lot of people who have left on advanced parole and picked up H-1B and came back or claimed they have done that. But the question becomes, have they? Because what happens at the border, they say, "Oh, you're automatic revalidation. Okay, get back in there. Get back in the country. Okay, the stamping, no. I-94, no, we don't issue anything. Automatic revalidation, go back in." What has happened? Do you think you got back on H-1B? That's no guarantee. Now, you can argue that with USCIS. USCIS is not that organized. A lot of times they're not that sophisticated. The documentation is not there, so it doesn't get caught. But it's 100% risky to play that game. So if you're on advanced parole, guys, let me repeat this so you understand. If you're on advanced parole and you're leaving the United States on an automatic revalidation to pick up an H-1B visa, that's not the intent of the automatic revalidation, and it is risky. Although we see a lot of it getting approved, it's really improper use of it and can be risky for your case.
Yeah, it's not highly scrutinized, and this sounds like the sort of issue that we would be arguing in court in a nightmare immigration case where somebody's, I was admitted on automatic visa revalidation, but that wasn't valid. And is it valid if it wasn't done properly? Things like that.
Well, you don't have to argue in court as long as you understand the rule and don't extend the rule, stretch it beyond its elasticity. You don't get in trouble, because if you stretch it beyond its elasticity, it's only luck. You're hanging on luck, right? And if you're lucky,
I just imagine,
it goes
5
back.
years down the road, Sam, somebody who needs that H-1B admission rather than a parole admission, or to achieve something in the United States in terms of immigration. Somewhere out there, a lawyer's going to have to argue one of these.
Yeah,
those
absolutely.
admissions.
Exactly, absolutely.
Yeah. So I'm going to keep on going here. From Hafiz Muhammad. My priority date is August 2022. My wife is rest of the world born. Ooh, interesting. We applied for I-485 a month back and received the receipt. No today for me. My attorney said that my wife might get this week. It says it went to the NBC. How long do you think it will take to get to the EAD? And do you think EB3, rest of the world, will get to August 2022? Next year. Currently, they're processing December 2021 for EB3, rest of the world right now. Well, so for Hafiz, I would say if you want to know how long it's going to take them, guesstimate, to process an EAD, I'm always an advocate for going to the USCIS website, uscis.gov, and clicking the link that says processing times. You can type in your form, I-765, which is the EAD form, which is what I'm doing right now. And it's going to be a C9 EAD based upon an adjustment of status. And if it's at the National Benefits Center, drum roll, they are saying it takes them 8 months to get to 80% of cases. So these things change and are updated all the time, and maybe your EAD is not at the National Benefits Center. I don't know, but the processing times are brutal. Yeah. As for August 2022, rest of the world next year, I would say, look at the January visa bulletin is coming soon. It'll be later this month. What we get in that visa bulletin will give you a preview as to what's to come in future quarterly visa bulletins.
I agree.
Okay. I sort of some commentary here. Well, I'll put it up here, but I think I just kind of addressed the question. Any update on visa bulletin movement for the rest of 2023 and 2024? Thank you. So a while back on the visa bulletin, on the October visa bulletin, I believe, they said, we are looking this thing on a quarterly basis. That's when we release new visas. So my thought has been to look to the January visa bulletin. When the January visa bulletin gets here, we will see what the quarterly visa releases really truly mean. Let's see here. From HF. H1 approved in May 2023 for 3 years until May of 2026. Traveled and entered U.S. on AP in September 2023. AOS. Would I be eligible for stamping pilot program based upon approved H-1B being on parole? So I guess this kind of mirrors the question that was previously submitted. If I'm on AP, am I going to be eligible for H-1B stamping inside the United States? And the answer is that remains to be seen. And as Sam pointed out, he imagined a scenario where the stamping is available for people on active H-1B status. If you're on advanced parole, you're a parolee, you're not on active H-1B status, they might have the means to screen that out. However, Sam, I can't help but think that perhaps they would just say yes because you have a valid H-1B approval.
Yeah, that's
One
very
thing I
possible.
would say is that we will see an actual version of the policy. So they say in December of 2023. December is here. So we will have it soon, and we will be live talking about it when it comes in, of course. Yeah. So maybe we take one more question here, Sam, and call it quits because it's 7:02.
Sounds good to me.
Okay. Um, so from ISA 2, payment increase after perm submitted after I-140 and green card files. Are these problematic? I haven't seen an issue in this, generally speaking.
Well, number one, the perm is for a future position,
True. Yeah.
not for the current position now. Um, and the prevailing wage um, is based on the job description for the geographic area.
Yeah.
And if the increase is insignificant, the issue is insignificant. If the salary differential is significant, then it may bring significant question as to whether or not the job you're doing is really is what's on the labor certification.
Yeah.
So there's a little bit of thinking has to go into that, answering the question, a little bit more an analysis that has to go into it. But that's basically to kind of whet your appetite. I know there's more there to it, but thank you all for listening to us today. Until next week, have a wonderful rest of the week. And 6 o'clock Eastern Time, I will be next to Brian in next week's presentation.
All right. All right. Thank